The People's Business is made possible by our partners, Solar Dynamics, the most efficient energy systems.
Good evening and welcome to the People's Business, our first show for the year. So Happy New Year to you. Now, today on People's Business, we will be looking at the Fair Credit Reporting Act. And to help me discuss that act today, we have Mr. ELSON GASKIN, who's the Bank Secretary with the Central Bank of Barbados and co-chair of the working group that advised on the act. Welcome to you, Mr. GASKIN. And next up, we have Ms. SHERISE King, an attorney at law and member of the said working group who advised on the act. Good evening and welcome.
Good evening and thank you.
And then we have Ms. SASHA SHILLINGFORD, a representative of the Barbados Bankers Association and also a member of the working group. Good evening to you.
Good evening.
Yes, good evening and welcome to all the members of the panel this evening. We're looking forward to a robust discussion. But before we do that, we'll go to commercial break. Welcome back. Now, last year, government passed the Fair Credit Report Act in Parliament. And this act, which is intended to create a regulatory environment promoting the development of fair credit reporting within this island. Now, we have the Minister, Ryan Strawn, who looked at the matter, and we'll now take a look at exactly what he had to say on this particular act.
What we are trying to engender here, sir, is a framework that allows for credit to be accessed by making the various provisions of data available to the financial institutions such that, sir, they can determine what is the creditworthiness of an individual, whether that individual, sir, is, well, a human being, whether it is a sole trader, whether it is a partnership, sir, however complicated the arrangement is, that that entity, the individual, that financial institutions have the capacity, sir, to know, in a sense, what is the risk that they are extending to you on behalf of their deposit takers.
And that was Minister Ryan Strawn. Now, let's go back to our guests and let's get a couple terminologies out of the way first so that people can understand the premise from which we're working. And I would perhaps like to start with you, Ms. Shillingford, coming from the banker's end. What do we classify as credit and a credit rating?
I didn't get the second part. Did you say credit?
Credit. Right. Tell us what's credit as defined by you all, and then the whole concept of a rating.
Right. So credit really is a wide term. It extends to any facility in which an institution, a business, whether it be financial institution or a retailer or any other type of entity, provides goods or services to a person or individual or other type of entity on terms that require repayment over time. So it could be the provision of a loan, it could be a credit card, it could be a line of credit, or it could be in a situation of a retailer where you've provided goods on a hire purchase arrangement. It extends to any general situation where goods or services are being provided or money is provided on terms for repayment over a period of time.
Okay, and the rating aspects of it?
Oh, in terms of the credit rating. So basically what the Act is really allowing for is where information is then pooled into one place. Information is collected from various sources, pooled into one place, collected, and a score is generated or a rating is generated, which is based on historic information of on a particular data subject or individual. Data subject is used in the Act, but on an individual, on an entity, on a business, and that rating really reflects what is the pattern of debt repayment that particular person or entity has.
Okay, if I can come to you now, Mr. Gaskin, to look at the parameters of this Act and how wide-ranging some of them are.
Okay, so the whole purpose of the Act is to provide better information for persons who are going to extend credit. One of the issues that arises in terms of extending credit is that not every party to the transaction might have the same information. So a person accessing credit could theoretically, let me put it this way, hide things from the person from whom they are going to obtain the credit. What the Fair Credit Reporting Act does is to provide for this information to be collected by credit bureaus, and then with the permission of the person who's seeking to access credit to be shared. And based on how well that individual has serviced their credit obligations, they will then get a credit rating or score, and then the person extending the credit is able to rely on that information to say, well, this person is a good credit risk or otherwise. So we've had credit bureaus in Barbados operating for some time, but this Act is now going to ensure that that situation is regulated properly, that the rights of data subjects who are the persons obtaining the credit are protected and recognized, and the Act is also going to make provision for the resolution of disputes between creditors or data subjects and credit bureaus.
Okay.
So the Act is pretty wide-ranging.
This is where I would like to bring in Ms. King. Now we're talking about rights and so on and information being shared on these said data subjects. Now, how much of my information can and will be collected, and how is it going to be determined how much of that is shared with the Bureau?
Well, with the legislation, there would now be a regulatory environment which would outline clear standards and procedures in place for the collection of data. And through that, you would have obviously rights attached in terms of ensuring that there's confidentiality of information, that there is adequate safeguards in place for the transmission of information and so forth. With the legislation, it makes provisions for the central bank to have a review of the data format that credit information providers and those who would be sending the information to the credit bureau, the data that they actually send. So, and the legislation even already goes into detail in terms of what information that would be. For loan applications, it would be the amount for the loan, the start date, the repayment terms, and so forth. That is some of the information that would be collected to determine the credit worthiness of the individual.
Okay, so how exactly are we going about collecting this information, and who will be collecting it? Would it be the loans officer that I'm approaching for the money to buy the car? Will it be the clerk at the furniture store I'm using? Who's going to be collecting it, and how?
The legislation starts off with identifying credit information providers, and that would be the financial institutions, the banks, credit unions, and also insurance companies to the extent that they have certain credit facilities in place. So these credit information providers would be the first set of entities under the legislation that would have a mandatory obligation to provide data to the credit bureau, and that would be done with the consent of the individual. We recognize that when we signed up to get credit, we usually do fill out an application form or an agreement in a sense, and it is in the legislation. It is hoped that that would be something that would be just clearly identified to the individuals as part of their application process. The legislation also provides that institutions can provide notice also on their websites, on signs on at their businesses and so forth, to clearly make it known that upon obtaining credit at these institutions, the information upon the success of obtaining credit, that information would then be shared to a credit bureau.
Okay, now when it's collected and collated, will it be done in, say, a computer program, a piece of software that everyone has the same access to, so that when we get the ratings, it is done in one set standard as opposed to varying modalities?
Well, that is something that the credit bureaus, they usually have their own technology in terms of the database for how they generate ratings or scores. But through the legislation, this would be something that would be reviewed by the regulatory authority, the central bank, as part of making sure that there are adequate standards in place for when that information is compiled and then generated in a method to reflect the credit worthiness, whether that is a credit rating or a credit score. So it is maybe a bit of a proprietary information in a sense, in terms of how credit bureau, once it is elected and once it is licensed, how they use whatever processes are in place. But it is something that would still have the oversight of the central bank ultimately.
Okay. I'm glad you spoke to the bank, because that's where I was coming next, to Mr. Gaskin, to look at the participating institutions and what control the CCB will be having over those institutions in terms of how it collects and shares that data.
Okay, so the central bank will be the regulatory authority for credit bureaus. It'll be responsible for licensing the credit bureaus. At present, there are 2 credit bureaus operating in Barbados, and there'll be a transitional period once the act is proclaimed to allow them to bring themselves compliant with the provisions of the act. Now, just to tap back to the question that you raised about collecting the information and so on, once the act comes into force, there will be automatic credit information providers. Credit information providers are the persons who will initially collect the data and then share it with the credit bureaus. So those automatic information credit information providers will be banks, credit unions, and insurance companies as far as their lending portfolios are concerned.
Now, when you say far, if you can stick a pin, does this distance also go across borders? Can the information be shared?
Yes, there is provision for portability of the information. So if, for example, you left Barbados and you went to work elsewhere and you wanted to access credit in whichever jurisdiction you took up residence, as long as the regulatory authorities in Barbados are satisfied that that jurisdiction has protections in place for the right to the data subject and security of information and so on, that information can be shared overseas. So you can use the credit rating that you've compiled here in Barbados to help you access credit if you have to move abroad.
Okay, well, that's good to know. It means that you don't have to work on building your credit once again. Now, I want to find out from Ms. Shillingford, when we come back, about the issue of hire purchase and how it's going to be impacting on that. We're going to be taking a break, and we'll be right back. And we're back. Before we left off, I wanted to ask a question of Ms. King, and this is pertaining to, with the new law, how is it fundamentally going to change how the average person can go about securing credit and hire purchase agreements? Will there be any major changes with this new act? You're muted.
Apologies.
Yeah.
As Mr. Gaskin highlighted, there already is an existing credit reporting system with 2 credit bureaus operating in Barbados. So therefore, what the Act seeks to do is that it seeks to create now a regulatory framework so that there is a clear standard applicable to all of the entities involved in the credit reporting system. So it somewhat acts as a codification and a guide in terms of the major questions in terms of when, how, where, what, as it relates to credit reporting, how all of those things would play under the legislation. So in terms of recognizing that there's an existing credit reporting system in place, the legislation merely seeks to ensure that there is now an adequate framework and a legal framework where there would be clear enforcement mechanisms in the event that there are any breaches of the standards that would be in place as a result of the legislation.
Okay. Ms. Shillingford, if I could get you to weigh in here on the issue of what happens when that score isn't favorable within the banking sector. What happens if my credit score is impaired?
Well, Wendy, when credit score is really just one of the factors that banks look at in extending credit to persons or its customers. I mean, a credit score that is unfavorable does reflect a certain pattern in terms of debt repayment of a customer, and therefore that will have an impact in terms of the decision to extend credit to an individual or not. However, as I said, there are other things that will be considered. You know, the circumstances of the individual, any collateral that might be available, and there are other things that could impact on that decision. So it's just one element out of a wide range of variables that will ultimately allow a bank to make a decision as to whether to extend credit or not.
How does the Bank Association feel about the Act generally? The
Bankers Association welcomes the Act. It is something that, as I said, I have been on the committee as a representative of the Bankers Association in the drafting and development of the Act, and therefore it is something that is seen favorably because it allows, by first of all providing the regulatory framework and setting clear obligations on all the stakeholders in the credit sector. You know, it allows individuals to really access credit that more quickly because it will allow the banks and other credit providers to make decisions a lot quicker. So, I mean, there's the flip side of those who have great credit and a great credit history, whether with utility paying, any form of payment of credit through a retailer, through banks, through their utility providers. So that person, if they don't have a lot of security or collateral to put up, it still allows the financial institutions or other credit providers to make a decisions very quickly on the history of that person's repayment patterns. So it is very helpful. It will certainly speed up the credit application and granting process. So we expect that, and on the other side of things, where credit providers are faced with applications where the applicant is really unknown to that institution, you're more likely to make a more risky decision. Loans can end up in default, and that does not really help other persons seeking to get loans, because really then it puts the credit providers in a place where they are going to be more strict in extending credit. They're going to want more collateral. So if it is that it allows credit providers to make more informed decisions and quicker decisions, then that can only benefit the economy as a whole.
Okay, it's time now for us to open our phone lines. You can feel free to call Mr. Gaskin, Ms. King, or Ms. Shillingford with any questions you have about the Act. 228-5562, 228-5563, the Fair Credit Reporting Act. That's our subject of discussion on this First People's Business for the new year. Now, if I can go to Mr. Gaskin now on the issue of the information share and breaches. What recourse is there through the bank for when those bureaus tend to breach the dissemination of people's information without permission having been granted to do so?
Well, the credit bureau must satisfy itself before it produces and shares a credit report that the data subject has consented to the sharing of the information. And the consent is obtained in a number of ways. Either when the data subject goes to access the credit, they will consent to their information being shared. That will be part of the credit agreement. Or there is something called implied consent, which is given by the credit information provider, giving notice on its website or by a conspicuous signage in its office that by entering into business with them, you consent to the information being shared with the credit bureau. The credit bureaus will be held to stringent standards in terms of their security protocols, even in terms of the persons that they hire and how the information is stored, and the persons that have access to the information. They will be held to a very high standard, and there are also criminal penalties for breaches of the Act. So there are quite a number of safeguards that have been put in place to protect persons' information. In fact, let me go on to say that when this Act was being drafted, the country was also in the final stages of the data protection, of readying the Data Protection Act for Parliament. And we ensured that this Act complied with the data protection pillars so that the rights of data subjects will be protected under this legislation as well. So as I said, there's some stringent statutory measures in place to protect the information of individuals.
Okay. Now, you mentioned earlier that there are 2 bureaus operating now. But in the event that I wanted to register a credit bureau, how would I have to satisfy the central bank to be able to do that?
Okay. Well, you would satisfy the central bank in almost the same way that financial institutions satisfy the central bank when they are applying for licenses. So you'd have to have a good business plan. We'd look at your access to capital and your capital base. We will look also at the fitness and propriety of the individuals who will be running the credit bureau. We will also be looking at your systems to see the robustness of the systems that you will have in place to protect the information that you will be holding. So it will be a stringent licensing process, much like a financial institution, not to the same extent, because financial institutions take deposits and so on, but it will also be a rigorous licensing process.
In that rigorousness, yes, what about the access of the final reports that come up? Is it only the financial institution that wants to question what my level is before they make their decision on whether or not to give me the product or service, or can other individuals access that information?
Okay,
like, say,
so
maybe a
other
court.
person. Well, the court operates in a different way, so the courts will have other mechanisms to get access to information without getting a credit report. But landlords, for example, might be able to get a credit report on a potential tenant. Also, if you're going to be hired in a job in which financial trust or probity is required, then your employer may also be able to access a credit report on you, because if you're a person that has to go into a job dealing with money and you have a bad credit rating, it may raise the inquiry of your employer or your potential employer as to whether they should let you have access to money. So there will be other persons for legitimate reasons and with consent who can get a credit report on an individual.
Okay, suppose I, Wendy, was giving a personal loan in excess of $10,000 to you, ELSON, right? Can I access that credit report?
Yes, with my consent.
Okay, interesting. Well, we'll see how it goes. Our call number is 228-5562, 228-5563. Now, some people are suggesting that the credit rating system is going to make it more difficult for me to access credit. Ms. Shillingford, is that going to happen?
Not at all, Wendy. As I was saying earlier, it may actually increase the likelihood of a person accessing credit. For instance, if a person has never had a loan before, but they have obviously they've lived on their own, they pay utilities, they have taken out furniture or other goods on hire purchase, and they have serviced those bills on time and in accordance with all the terms and conditions. That also forms a credit history. So there are times where there are other factors now that can play into showing that you are a person who honors your obligations, which is also important, other than just other loans with financial institutions. So that is a factor that is critical as well. Also, where an individual does not have, or for a small business person may not have sufficient security to put up to access loans. Again, showing that you have personal loans. If you're a sole trader, you've had personal loans, you've serviced those loans well, you've serviced all your other debt obligations well, will then give you a good credit score, and you may not, the lender would not necessarily need to rely as much on that security or collateral in every instance to make a decision as to whether to extend credit to you. So, I mean, a lot can depend on, you know, the credit score can really reflect a person's obligation in terms of how they view payment of their debt obligations. So
Okay.
it can increase your ability to access loans, and it can speed up that process for you as well.
Okay, thank you. We have a caller on the line. Good evening to you.
Yes, good evening. That may be a little issue, but I had an incident about the credit rating. This was a couple of years back. I bought a very small kitchen item for $90 something in a store. And it was faulty. I paid in cash, but I had my bill. It was faulty, and I returned it, and they took it back and gave me a new one. Okay? 5 years later, I went to another store to buy a large kitchen item, like a fridge. So I said, is it possible that I can make it like for 3-4 months payment? And they agreed. Then the manager, whom I know, I bought very often in that shop, she called me and she said, I am very sorry, we cannot give you the credit because I should not tell you, but we checked your credit rating and it's very, very negative. I said, wait a minute. I didn't buy anything on credit except my car, which I regularly paid. So then I went to the credit bureau, which was down in Christchurch at that time, and I said, hello, I want to know what's going on here. And they were very confused, and they said, yeah, we take it down immediately. So for 5 years, I had a negative credit rating. I mean, and I do have another question. If you go and buy something on credit, do they need my permission when I say to check my credit rating? If I say no, they don't need to give me credit. If I say yes, there's no problem. This is my question, actually. But through this incident, I had basically for 5 years a very negative credit rating through this little thing. Can you tell me something to this? How is this possible that they can do that?
Okay, have you gotten the question fully, panel?
Yeah.
I believe so, yeah.
Okay, so who's willing to answer?
Well, okay, so, and I don't want to seem dismissive of the caller, but sometimes in human events, errors can happen. But under this legislation, if a data subject finds that incorrect information is being shared or there is something else that needs to be corrected, they can request the credit bureau to correct the information. They can also request in certain circumstances that the credit bureau stop sharing the information for various reasons. And if the credit bureau wants to continue sharing that information, they have to inform the data subject, and the data subject can also apply to the central bank to have the credit bureau directed to stop sharing the information. So there is recourse in circumstances like that, and what is more, the data subject can request once annually, free of charge, a credit report on themselves, so that if there's information there that needs to be corrected or rectified, they will see it and they can make that request as well. So this new piece of legislation does take into consideration the type of errors and scenarios that the caller has mentioned, and has put in place mechanisms to ensure that situations such as those are minimized, because we've heard other similar stories in the course of preparing this legislation, and even in the aftermath of its passage, we've heard similar stories as what the caller outlined. And we are hoping that with this legislation, those scenarios can be minimized.
Yes, we're actually hoping not only minimize, but a thing of the past, so it doesn't appear as an obstacle. Well, we're going to take a commercial break, and when we come back, we'll be back to our phone lines. Good evening and welcome back to the People's Business. We are discussing the Credit Rating Act. Good evening to you, caller.
Good evening.
Go right ahead.
Oh, good night, Wendy. Good night, and good night to the panel. Just want to ask a quick question about the credit bureau and their rating. Why it is that if you bring something out from a store or you deal with a bank or a business, any finance institution, why it is that you pay off for the item, and when you pay off for the item, you clear the item, and then if you want to go back in another year or something to get something from a store or a car from an institution, like I say, a finance institution, whether it's the bank or the credit union, why it is that the score is still on if your credit, they check the credit rating and it's 5 between 1 to 10, or they say it's 5 and they don't take it off, why you have to wait the next 5 years? I don't understand why that still happens. If you pay for the item, I'm trying to find out if you pay off for the item or whatever you had from any finance institution, why it is that your credit rating is still at 5 and you had cleared for the item or you clear whatever you finance. I can't get that question. I was trying to call the credit bureau about that, and I never got a positive attitude or vibes about that, and that should not be. If you clear something in your name or ever and you clear it, that should be off. You have to wait till that credit number stay there for another 5 years. I don't think that's fair to the person.
Okay, if I could get Ms. Shillingford first and then Ms. King in terms of a legal perspective, I think, because it seems what she's asking is why, when the debt is fully paid up, why don't we go back to a fresh slate to start back her rating, from what I'm gathering. Yes, Ms. Shillingford?
Okay, well, the credit score is, because it is generated by historic information, so basically it is looking at your historic pattern of repayment of debt. So there will be an automated formula for generating that score, which is looking at all the information that the credit bureau has in relation to all debts or credit that would have been extended to that particular individual or entity. So repayment of one particular debt is not necessarily going to change a score, and that also would depend on, was that debt repaid within the time or in accordance with the particular repayment terms. So there's a lot of things that impact on the score. So as I said, a repayment of one particular credit or debt is not necessarily going to impact the score. I would say, however, that you are entitled as an individual to get information on your own credit and how that, and basically you can request a credit report so you can maybe see what other information the bureau may have that might be impacting on your score. So I think that is one avenue that should be available to you. and that you should pursue. Luckily, this act does make it, it is built into the regulatory framework that where requests for information or where an individual actually requests their own report, that is provided within a specified time. Individuals are also permitted under the act or entitled to get one credit report on themselves per year for free. So the act does sort of provide specific guidelines where individuals feel somewhat aggrieved by whatever may be leading to their score. At least they can access the information that is generating or assisting with generating that score, which may help them to understand the situation better.
What I want
and
to
of course, there are the options for making objection if there's anything inaccurate in the report or any issue they may have with the information contained in that report.
That's the part I was coming to, the issue of incorrect information being within the report. What recourse, what are the channels, what are the steps I should take in order to have that altered? Ms. King?
Right. So in terms of disputing information, if it is believed that it is inaccurate, the first recourse would be to send that dispute to the credit bureau for them to have their own investigations. And that would mean investigating from their end and also from that of the credit information providers that would have supplied them the information. Because the credit bureau merely seeks to compel the information in the form of a credit rating or score, using what would be credit history information, how individuals would have serviced their debts in the past in accordance with whatever terms or obligations that would have been set by the institution. And from that would be what would be used to generate either the credit score or credit rating. So in terms of the first question, in terms of the query, in terms of the date of settlement, what you're recognizing is that you're using your payment patterns to determine then how you would have serviced your debts in the past and also your credit worthiness. But if there's a belief that that is inaccurate, the first step would be to dispute it with the credit bureau. If it is that there isn't any satisfaction in terms of whatever the decision or determination comes out from the investigation, then the data subject would have recourse to the central bank that would also do its own investigations into the matter. And then there's also under the legislation a tribunal which would be set up to have a final review in terms of any disputes and to make a decision with respect to those disputes.
Okay, we have a caller on the line. Good evening to you.
Hello?
Don't listen to your television, ma'am. Just go ahead and ask the question.
Yes,
Turn your television down.
This question is specifically for Mr. Gaskin, and I would like to know from him what is the difference between the credit bureau and its functions and a collateral registry.
Did you hear her clearly, Mr. Gaskin?
Not only did I hear her, I believe I know who it is as well.
Okay.
But the difference, the credit bureau is to, as we've been saying, collect information, the credit information of data subjects and collate that into a report. The collateral registry is, like for example, now, let me give you a quick example. Right now, the Corporate Affairs and Intellectual Property Office is responsible or is the entity where bills of sale over vehicles and other chattels are registered and recorded. The collateral registry will perform a similar function where there will be the registration of various items that are held as security for monies lent and advance. Right now, as I said, one of the primary forms of collateral that we would have apart from real property would be motor vehicles. But when or if the collateral registry comes into being, there will be other types of security interest registered. So the credit bureau is to collate and provide credit information to users of the credit bureau on request, and the collateral registry is supposed to record and document a broad range of security interests. Both entities are supposed to be going towards the same trust, and that is to increase the ease of doing business in Barbados, increase credit facilitation, and hopefully development. So the two entities will play similar roles. Will help in terms of economic growth, but will perform different functions.
Okay, we have another caller on the line. Good evening to you.
Good night. Thank you very much for quite an interesting discussion. This question is directed to Ms. Shillingford. I just wondered if your ability to pay your tax, whether it's personal or your business tax, would also be taken into consideration in determining your credit rating. Thank you.
Did you get it clearly, Ms. Shillingford?
I did. Thank you for the question. Okay. It's a good question. Right now, I mean, there are certain designated providers of information at the moment, but there are other, and then that would be under the Act, the three that have already been designated would be the banks, the credit unions, and the insurance companies, and the credit unions and insurance companies. However, the central bank has the right, or maybe the minister has a right to designate other, central bank has a right to designate other entities as credit information providers. And that can include all the utility companies, government registries, government offices, or any credit information provider. So I would think that the tax authorities could be one, or BRA could be one institution that could be designated, but there's a general allowance for for the central bank to determine whether another institution should be also designated as a provider. And once that institution is providing information to a credit bureau, then that information then forms a part of your overall credit information and can contribute to the generation of a credit score or to your credit report.
So therefore, if it's found that I've not paid my land tax for the last 12 years, but I've paid all my other bills and debts, I can still end up with a low score.
Well, sorry to interrupt, Sasha, if I can. At the moment, BRA is not contemplated as one of the entities that will be designated as a credit information provider. So at the moment, the answer would be no. So that BRA will not be one of the entities that the central bank may designate as a credit information provider. As Sasha said, it more applies to, for example, the utility companies, various registries, and a few others, but BRA is not contemplated.
Okay, thank you for that. We will be going to break, and when we return with the People's Business, we'll discuss more about you and your credit score. Good evening, we're back, and it's straight to the phone lines. Good evening to you.
Yes, ma'am. Good evening. I have two questions. First, is there still a statute of limitations to the debt? And how can I get that removed, especially if it's like 11 years? Being that is something against me, so that's what I want to know.
ELSON?
Yes, there's a statute of limitations still in relation to debt. Ordinarily, it's 6 years from the date that the debt was incurred or last acknowledged. So if I had, I incurred a debt 10 years ago, the statute of limitations would begin to run. But if, say, 6 years ago, when the debt was 4 years old, I acknowledged the debt or I made a payment, the statute of limitations would start over. And then if I went 2 years without paying and then I paid again, acknowledged the debt, the statute of limitations would start over. So yes, there's still the statute of limitations, which is ordinarily 6 years. I'm not sure if I understood the latter part of the question in relation to 11 years and how could that be removed. I didn't quite
I think he
get
wanted
the question.
to know
I don't
the
know.
timeline to determine whether or not, if after 11 years, he's good to go.
After 11 years, he would be good to go so long as there is a 6-year period in which he did not acknowledge the debt in any way, and there was no corresponding demand made by the debtor.
Okay,
by the creditor, sorry.
That's an interesting point there. Now, let's look at these credit bureaus and how they have actually been functioning in determining when information is given out to a particular institution, organization, be it the bank, the credit union, what have you. How do I initially approach the bureau to say to them, I need to get XYZ on ELSON? Is it something that I find on a web portal they may have? Do I just pick up and call? How do I show them that I am indeed bona fide in wanting this information? Anyone can take
right.
it.
So if I will take the question, because we recognize that there is a existing credit reporting system which was not necessarily regulated, so there wasn't any law setting the standards in place. So with any business, you would recognize that as part of their operations, there would be standard contractual arrangements in place, and then also recognizing still key principles in terms of consumer rights. So information would have been shared or should be accessed with the consent of the individual as the founding principle for the disclosure and also of information. That is disclosure to the credit bureau, and then from the credit bureau to the entity seeking to request a report or the individual themselves. So in terms of the operation, it is believed that it would be something where you would have contractual obligations in place, where the credit bureau would do their internal investigations into the company seeking to do credit or the individual seeking to do credit, making sure, still in accordance with what some of the principles we have under the legislation, making sure that you have the identity of the individual clear, so that you're sending the information to about the correct person, and also ensuring then that consent is obtained, whether through an application form or an online consent given by the individual.
Okay, Mr. Gaskin, in terms of the bureaus, and now we have the Act, what more rules have been placed on them in terms of how they must operate day to day? How much change has to be brought to their operation to be in sync with the Act?
Well, I am not that familiar with the day-to-day operations of the two credit bureaus, but I know that there will be a transition period whereby they have now to apply to be licensed under the Act, and in licensing, they will go through the process of as if they were almost starting from scratch, where we'll be looking at the operations, looking at the shareholders, looking at the directors, looking at the business plan. As I said, one very important matter will be the robustness of the systems that they have in place to protect and secure information. So it will almost be a new look at their operations and ensuring that their operations conform and comply with the provisions of the Act.
And what's the timeline for them to do this?
I believe it is 6 months from the passage of the Act. Not from the passage of the Act, from the proclamation of the Act and it coming into force. I believe it is 6 months.
Okay, that's interesting. Now, the
I wanted to supplement a point that Cherise made in relation to the last question you asked about persons who wish to access the credit information. In most cases, the persons accessing the credit information will also be persons who are providing the credit information. So, for example, a bank will provide information on data subjects, and it will also seek to access information. So there will be subscriber agreements put in place between the credit bureau and financial institutions, for example, to be able to receive and give information. Same would apply to companies who do business on hire purchase, for example. So in that way, the credit bureau should, for the overwhelming part, know exactly who they're doing business with, know who they're receiving information from, and who the credit reports are going back to. So that was just to supplement the points that Cherise was making.
Okay, I want to stay with you, ELSON, because I want to find out about the central bank's role in terms of governing the operations of these bureaus. Once you've done all those checks and balances and they're registered, how often thereafter that are you going to be going in, following up, checking up?
Well, in our regulatory rules, we have a regular schedule of inspections that we do in terms of the entities that we regulate. We do on-site as well as off-site in inspections. So I can't tell you no because the process hasn't actually begun, but I can't tell you no how often that we would be making those checks in the course of a calendar year. But I would certainly think it would be no less than annually, looking at their audited reports and such other information as is required. So we do have a regular schedule for the entities that we currently regulate, and the same will apply to credit bureaus. But that licensing framework is still being developed. Of course, a credit bureau is a different sort of creature from a deposit taking institution, which, if not prudentially regulated, could have disastrous effects for the real economy. But the protection of the information which the credit bureaus will hold is something that is of the utmost importance as well. So when the licensing framework is rolled out, it is at that point that, based on the risk involved, we supervise and regulate from a risk perspective. So based on the risks involved with that kind of business is when we will determine the regularity of inspections. But as I said, most of our monitoring is ongoing. It's not something that we do this week and we don't do next week. It's ongoing, but there may be certain trigger points or certain information that we will call for at a given time. But our monitoring is constantly ongoing.
What about an instance whereby you find that, as I was talking to Ms. King about it, where a number of people are challenging the ratings having been issued by a particular bureau, and say within the space of a month you have maybe say 10 to 12 people disputing it. They've not been satisfied after the bureau has done its investigations and they have come to the bank for some recourse.
Right. Well, there's another piece of legislation that is currently being drafted to accompany this and other pieces of legislation in the financial space. That piece of legislation will establish a financial services tribunal that will hear and determine disputes relating to matters emanating from the relationship between credit bureaus and data subjects, and also from other financial relationships. So it is that body that will be charged with the responsibility to regulate and adjudicate on disputes and hopefully to craft an appropriate remedy.
And hopefully, Ms. King, the establishment of these other groups will not be too far behind the proclamation of the Act?
It would be hope so. Unfortunately, I don't have a role in terms of that one, but it would be hope, because you still want to recognize that you have legislation in place, but you want it to be practical and something that, you know, individuals know that they would be recourse for the breaches to a higher level, such as the tribunal.
Okay, I want to thank you all thus far for all that we've been discussing on the Act. Remember, our call numbers are 228-5562, 228-5563. We'll be going to break, and when we come back, we'll continue our discussion. And we're back. Before we left off, we were talking about the tribunal, which is going to be accompanying the legislation of the Credit Rating Act, and how individuals can get recourse if they're not satisfied. But in that point of satisfaction, Ms. Shillingford, we also spoke about it improving Barbados economically. Do you see this new act, which is going to be coming into play, helping to deal overall with the bad debt and debt management within our financial institutions?
The act definitely will assist in that regard. Right now, a lot of, even though there are existing credit bureaus operating in the Barbados market for some time, the entities providing information to those credit bureaus is not as far-reaching as the Act is going to allow for. And therefore, credit providers are going to be able to get a much wider view of persons who are applying for credit through the Bureau. And once the Act is enacted and more entities come on stream in terms of being credit providers. So the more information that is available to credit providers is the more informed their decisions are, the more accurate their decisions are in assessing whether an applicant is a good credit risk or not. And as I'd indicated before, high numbers of bad loans do not assist an economy. At the end of the day, persons are, you want to be able to institutions don't want to be spending their time and efforts running down bad debts. We want to know that persons who are good credit risks are getting access to funds and getting access to funds quickly, and those who may be attempting to trick the systems, whether through jumping around in terms of getting loans with different institutions because they feel that if a loan is bad in one place, they can go somewhere else and get another loan. That really does not help the system. What we want to do is assist those who are really who are working hard, contributing to the economy, paying their debts. They may not, as I said before, have access to a lot of security. They may not own property. They may not have a lot of persons who can be guarantors for them. So, I mean, if you are a person who's had a sound credit history, you want to know that you can go to your institution. Your institution has a wide view of who you are and a historic view of how you pay your debts and can make a quick decision and help you to progress. And as I said, for small business persons, sole traders, individuals, that can only benefit the economy, and as well as the markets that open up where your credit information can be shared overseas. It can open up other opportunities for accessing credit in other jurisdictions. So I think those are positive effects once the Act comes into play.
Okay. ELSON, if I can come back to you to look at the whole issue of this new Act and how it is going to improve Barbados's financial and economic standing overall. Paint for us the picture as to how it can help to alter, enhance the ranking of doing business in Barbados.
Well, Wendy, there is a direct correlation, studies have shown, between access to credit and development. Most of the times, if a developer is going to come in and put on a large hotel, for example, chances are he's not going to use his own money. He's either going to get debt, so he's either going to borrow from a bank, or he's going to have investors, whereby that is then called equity, or there's going to be a mixture of debt and equity. But both debt and equity can be termed forms of credit, albeit that they're repaid in different ways. So there's a direct correlation between development and credit. Most persons in Barbados, I would want to believe, would not be able to own a home or car, or maybe start a business without access to credit. So credit plays a definite developmental role. So the greater ease there is to good credit, we should see that reflected in startups and thriving businesses. We should see that in homes being built, etc. So if there's greater access to credit, and as I think Sasha made this point earlier, less reliance on actual physical collateral, but more reliance on the fact that this person is a good credit risk. Risk is involved in everything. This person is a good credit risk. They've accessed credit many times before. They've met their obligations. So therefore, we don't have to ask them for real property plus an insurance policy plus a guarantor. You know, we can feel free to access this, to extend this credit on far less stringent terms. That person accesses the credit, they do what they're supposed to do, they repay, and funds are then there available for other persons to use through the repayment of the credit facility. So that, I hope I've answered your question, okay. But that is how, you know, if things function optimally, it should work.
This question is both to you, ELSON, as well as Ms. Shillingford. Has anyone mapped out some projections once this act gets going as to how soon we might start to see this improvement, this increased credit lending, and the move from high bad debt figures to our people understanding a credit culture where they have to be more responsible and responsive?
I can hazard a start, but I can't speak for anyone else except perhaps, and I'm not even sure I can speak for all the banks. I don't know that there is a way of projecting the positive effects of the act. I think it is really more dependent on how quickly we can add additional providers of information. Because the more information that is out there in the credit bureau that they have access to generate scores and reports, is the more accurate then credit decisions can be made. And that is when you really get the positive impact. So I think it depends on how quickly not only the providers need to get themselves in a position, I think, to be designated as credit information providers, ensure they have these systems and procedures in place to comply with the act, and then start sharing the information. And I think that, as I said, the more information and the more providers that there are, then you will start seeing the act. But in order to really project when that will occur, there are so many unknowns built into that it would be very difficult to do so. I don't know if ELSON, if the central bank has a crystal ball that they were able to do that type of analysis.
We have crystal balls, but not any that are that clear, Sasha. But I'm told there's an Eastern proverb that says that the longest journey begins with but a single step, and that is the way that we see this. In repeated doing business reports done on the country by various international institutions, having functioning credit bureaus and the regulatory framework has been touted as another step in the direction of the ease of doing business. These things take time. Sometimes they happen quickly, sometimes they happen at a more measured pace. But I think at a more measured pace, but I think what is important is to have the framework in place so that we can get going, so that maybe, 3, 4, 5 years down the line, we can look back and we can see the wisdom of doing this in 2022 rather than in 2027 saying, well, if we had done this 5 years ago, just imagine where we would be now. So we have to make that start and to build on that start incrementally. And this legislation, along with the other pieces of legislation that will be coming on stream, represent that start.
Are there any areas of the Act which may, for the average layman, create any misconceptions or misinterpretation? Or has the committee ensured that everything is crystal clear?
That's a good question. I wouldn't want to be so presumptuous as to say that everything is crystal clear. We human beings drafted the legislation, and persons will interpret things in different ways. But I think it is basically straightforward that persons will understand, and some of the basics involve matters such as you know, there must be your consent is necessary for your information to be shared. That if there is incorrect information in your credit file, you have a right for it to be corrected. If you also have a right to access a credit report on you at least once a year, free of charge, and you can apply to have a credit bureau stop sharing your information if you no longer wish it to be shared. It has to go through a process if that's to be done. I think it's straightforward for persons to understand that their information can sort of like travel with them, what we call portability. If you have to move away from Barbados, you don't necessarily have to build up a new credit rating in the place that you move to, and also that there will be a convenient forum for the resolution of disputes. So I think, I can't remember how many principles are just enunciated, but those 6 or 7 principles, which I think will mostly concern the average person, I think that those are pretty easy to understand. And another one that I will add is that the credit bureau is supposed to take all necessary measures to protect and secure your information, even including the persons inside the credit bureau who are going to have access to that information.
Okay, I want to thank you for clearing that up. It's time for us to take another commercial break, and when we come back, we'll talk a bit more about the Act. And we're back. Now, before we went off, we were talking about the time it will take for the Act to show how it's really working and the impact that it will be having on us. But before we got to that place, we had a working committee. And I want to find out from you, the members of the committee, first of all, your individual roles in this process in terms of getting the Act toward Parliament for it to be debated and discussed, and also what each sector hopes to be able to derive from having this Act come into full being. I'll begin with you, Ms. King.
Right. So the technical working group, I would say, would have been a collaborative effort. So not necessarily having specific roles in a sense, but more so using experience and knowledge in our various fields to collectively come together to make sure that we have a legislation to address a number of issues that would arise within the credit reporting system, and ensuring that there are adequate consumer rights as well. So in terms of I would say it was more collaborative effort using the background and experience that we would have, legal experience with credit bureau services, the banking sector, members of the credit union movement were also present. I believe also representatives from the Fair Trading Commission as well. So collectively coming together that we have a piece of legislation to address all of the issues that we believe would be relevant to a credit reporting system, and making sure that we still recognize that consumer rights would be protected as well.
Okay, now, since we're talking about the protection of those rights, there's one thing I want to raise, and that's a timeline. What kind of time frame do I have in terms of getting my dispute not only filed, but handled?
Right. The legislation does outline certain key timelines. I believe could be wrong. I don't know if the others will jump in, but I believe within the investigations to the Credit Bureau, the timeline set is 7 days. So, but throughout the legislation, we recognize that timeliness is key to dealing with disputes and matters of this nature. So there are key timelines set within the legislation to make sure that things aren't left outstanding and awaiting the decision, that some sort of recourse happens within a timely manner.
What is timely? For you, it might be 2 months. For me, it might be 7 days.
Right. Well, we believe that, still noting that there is a need for investigation first. I believe that time frame of at least 7 days would be adequate. But you would find the legislation specifies timelines throughout, and even in terms of the supply of data, making sure that it is up to date. It is a minimum of at least a month, in terms of which is usually the standard repayment pattern and so forth. So the legislation is drafted in a way to recognize that in a custom with reasonableness and in a custom with certain standards as well that would occur in normal business practice, that those timelines are clearly outlined to give greater efficiency to the system.
Okay, and in trying to get that dispute issue handled, what then, after I get the bureau, etc., is there a time limit on when I can actually, if I want to go forward with that matter, if I'm not satisfied, take it to the central bank?
No, there's no time limit specified in terms of if it is that your recourse is the recourse taken by the credit bureau isn't satisfactory. There is no specific timeline, but obviously, as you said, most people in the situation, timeliness would be key. So we would expect that individuals will still proceed promptly to the central bank if it is that the decision which the credit bureau made isn't satisfactory to them.
Okay, Ms. Shillingford, you were speaking about the fact that, you know, you would want a couple more institutions to be added to that reporting aspect to be licensed under the framework. So outside of that, were there any other areas maybe that the banking sector would have wanted the legislation to include, or for the most part, is it satisfying your needs generally?
I would say that, I mean, the most critical thing that, the most critical achievement that the legislation has done for the Bankers Association is making it mandatory for banks to share information with credit bureaus, as well as making it clear how the consent of customers will be obtained in order to share that information. So it is previously we would have been reliant only on the specific signature of a customer to share that information with the credit bureaus. The Act has expanded the consent to include notice given to customers. It's not always easy to obtain a signature, particularly in the times that we're operating in, where a lot more is being done virtually. Customers are not always in the jurisdiction where you are dealing with, and therefore a signature is becoming more and more outdated. Now you want to have other options where you have electronic click to signify that you are consenting, or you have made sure that customers are aware of what you're going to do through adequate notice to them, and then they have the option then to determine whether they want to do business or not with you. So those things have been clarified in the Act. And again, just the method of providing the information, we are very, very concerned with security of information as well as banks, and therefore regulating how that information is kept, what is done with it, who accesses it, is very critical to banks as well. So I think there are many, many positives by the legislation, and the bankers have really been looking forward to the passing of the Act.
Okay, well, that's good to hear. You now, Mr. Gaskin, is the central bank fully satisfied with how things have gone and the role which the bank has to play in the regulation of this Act?
Yes, I would say that in large measure the central bank is satisfied. We understand our role in continuing to develop the economy of Barbados in positive ways, and we see this as another step. We in Barbados were lagging a bit behind some of the other jurisdictions in the Caribbean when it comes to this type of legislation. Jamaica, Guyana, Bahamas, some countries in the OECS, for example, have had this legislation for almost a decade now. But what that we benefited because we were able to construct our legislation in a way to take account of the gaps of some of the regional legislation. We looked beyond the region when we were developing the Act, and we also looked at the model legislation that that CARICOM has been pursuing, so that we think that the Act that we have come up with is a good one and should serve Barbados well into the future. Of course, as things change, so will we obviously need to change and to keep abreast of developments. But for this snapshot in time, we are pretty satisfied with the legislation.
Okay, we're coming toward the end of our program now. And if I can come to you first, Ms. Shillingford, because there's just something I want you to clarify for me, and that is what constitutes notice. Is an email enough, a WhatsApp message, a text message? What constitutes notice? And then give me one parting shot as to your greatest takeaway from what the Act will offer.
So notice is either erecting a sign in a conspicuous place in your place of business. It can come in other forms, a notice on your website. It can be a direct email to customers. It really is any method where you draw your customers' attention to the fact that you will be sharing their information with the credit bureau. So that is. The legislation gives you quite a few options for what would constitute notice, but at the end of the day, the critical factor is that it must be brought to the attention of your customers and they, and not hidden in an inconspicuous way.
Okay, your parting shot.
I think my greatest I think the greatest takeaway from the legislation is that this is going to give is really going to give greater access to credit, and is something to look forward to. And I think that Barbadians are going to, and other people living in Barbados are going to really see improvement in lifestyle as a result of quicker access to credit and maybe less stringent credit decisions.
Okay, you, Ms. King.
Right. So the greatest takeaway from the legislation would be, as an attorney, law may brings a level of certainty, so that there is a general awareness and understanding in terms of all the rules, standards that would be required for the credit reporting system. So there would be clear certainty in terms of coming from the credit information providers in terms of their obligations, data subjects, the individuals out there in terms of their rights. And once you have this general understanding and knowledge in terms of how the system will operate, that should lead to greater efficiency, wide use of the system, and also greater access by individuals having understand the benefits that can also come arise in terms of having a good credit report as well.
Okay, and quickly to you, ELSON.
My greatest takeaway is perhaps a mixture of some things that both Sasha and SHERISE have said. I am looking forward to the a reduction in the reliance of large collateral and a greater reliance on the credit history of the data subject and to assure a financial institution or other credit provider that that person is a good credit risk. I'm also looking forward to the developmental role that legislation such as this will play, and I'm also as well looking forward to the protection of rights of data subjects, because that's something that we hear people cry out every day for not having sufficient protection. So any legislation that is going to buttress that protection, I am all for.
Well, that's good to hear and good to know that we have something that will protect us and our credit. The Fair Credit Reporting Act, that's been the discussion on this First People's Business for the year. My guest, Mr. ELSON GASKIN, the Bank Secretary, Central Bank of Barbados, Ms. SHERISE King, an attorney at law and member of the working group that advised on the act, and SASHA Shillingford, a representative from the Barbados Bankers Association, and she also sat on that working group. I wish to thank all three of you panelists for joining us this Sunday evening, and I also wish to thank our audience and our callers for being with us. That's been The People's Business. Do have a great evening.